Welcome to the Bible Bear Consortium, Waco. So what is the Bible Bear Consortium? The name is actually a linear explanation of the event. First and foremost, we present a topic from a biblical perspective in an environment where beer is sold. Then we have a consortium or a Q&A. So if you are here, we encourage you to be a very, very good patron. The standard is that at some point, Eddie and Amos, the bartenders, should say, "Stop tipping, that is too much money." That is the standard. Are you still accepting tips, sir? Yes. Okay. So we're good. You can tip. Tonight's speaker. Ever since 22nd chapter of Matthew, where Jesus said, "Give to Caesar what is Caesar's and give to God what is God's," we've been discussing the question that Bill Clinton asked, what the definition of is. And tonight I hope to have that somewhat resolved. Tonight's speaker is Dr. Francis Beckwith. He's a professor of philosophy and church-state studies at Baylor University, where he also serves as associate director of the graduate program in philosophy and co-director of the program on philosophical studies of religion in Baylor's Institute for Studies of Religion. With his appointment in the Department of Philosophy, he also teaches courses in medical humanities, political science, religion, and church-state studies. From July 2003 through January 2007, he served as the associate director of Baylor's J.M. Dawson Institute of Church-State Studies. He's taught at Notre Dame, at Princeton. If it is in print, he has been quoted. It is published, he's been published more than twice. His bio is lengthy. His books, amongst my favorites, he has a forthcoming book on Cambridge called Taking Rights, R-I-T-E-S, Seriously, Law, Politics, and Reasonableness of Faith, Politics for Christians, Statecraft and Soulcraft, Return to Rome, Confessions of an Evangelical Catholic, Defending Life, a Moral and Legal Case Against Abortion Choice. He co-authored To Everyone an Answer, A Case for the Christian Worldview with William Lane Craig and J.P. Moreland. Tonight, presenting the separation of church and state, what it is and is not. Please welcome Dr. Francis Beckwith.
What a delight it is to be here. This is actually, I think, the first lecture I've ever given in a bar. In fact, this is a pretty significant event. In March, I spoke in Vatican City. So I think I'm safe in saying that I may be the only person in history to have spoken both in Vatican City and a bar in Waco in the same year. I'm pretty sure about that. The topic, we're also on live stream, by the way. You guys know that. So we can talk about the Amish, because I know they're not watching. This isn't a stand-up. This evening, I'm going to talk about the question, actually the phrase, the separation of church and state, and the question, what is it and what is it not? There's so many ways we can go about discussing this issue. And what I want to do is kind of introduce you to the question by talking about what I think is the present situation in the United States about church and state, how people think about not only the relationship between church and state, but the relationship between religion and politics, which is not quite the same thing. And then I'm going to go over a kind of brief history lesson about some of the reasons why we use the phrase separation of church and state, and the different factions that existed at the American founding and how we got here today. So let me begin with just the present situation, give you a kind of feel for it. I want to tell a story. So over 11 years ago, I was invited to speak at Texas Tech University. You may have heard of that school. It's in Lubbock, Texas.
Guns up!
Have you ever been to Lubbock? People from the moon go there and say, "Wow, what a wasteland." So I'm giving this lecture at Texas Tech Law School. I was invited by the Christian Legal Society as well as the Federalist Society to give this lecture. And it was right at the time in which there was a lot of debate about the teaching of evolution in public schools. I had actually just completed a book that had just been published called Law, Darwinism, and Public Education. And so I was invited to give a lecture on the sort of state of this debate in American society. And after my lecture, there was a question and answer period, and there were a number of people in the audience anxious to ask questions, two of which were professors in one of the science departments at Texas Tech. And the gentleman raised his hand, and keep in mind what I was discussing. I was discussing the relationship between theology, science, and public education, and giving not only legal arguments, but talking about the different philosophical points of view in terms of the relationship between science and theology. So this gentleman raises his hand and he says, "Professor Beckwith, all you've given us today are nothing but religious arguments." And I paused for a moment. I said, "Wow, I'm relieved. I thought you were going to say they were bad arguments." Now, actually, it deserves a bit of a laugh. Why did I say that? What accounts for that quip? Well, I actually explained it to the audience, and this is what I told the audience. I said, here I'm giving a lecture about the relationship between several different disciplines, law, theology, science, and talking about the different points of view about human origins, why certain people hold these views and why others don't. And instead of actually dealing with the quality of the arguments I'm offering, this gentleman believes that the way you resolve issues like this is to simply put an adjective in front of a term like argument. And the assumption behind the use of that adjective, religious, is this. He's assuming that any position that is tightly tethered to a theological position somehow is sub-rational by its very nature. And this tends to be a kind of dominant view in some circles. Now, that's not what, for example, the American founders, when they talked about the influence of religion on politics, or more concretely, the separation of church and state, they weren't talking about that. But you'll see later when I talk about the history, how we got to the point where there's been a shift from an understanding that the church and the state are separate institutions with their own ends or purposes, to a kind of almost hostility towards any sorts of views that are in any way connected to theological traditions. I'll give you one example, and this is actually has to do with a case that the Supreme Court dealt with last year. Many of you are familiar with the case of Hobby Lobby versus Burwell. That was a case involving the company Hobby Lobby, which is a closely held corporation, which means that it's owned by a family. It isn't one that which you can purchase stock or vote for the board of directors or anything like that. It's a closely held corporation, family owned, that was required, like all businesses under the Affordable Care Act. Actually, technically that's not right. They were forced by the Secretary of Health and Human Services, based on a regulation she issued that she was empowered to issue by the Affordable Care Act. So there's actually some interesting technical questions about administrative agencies and their powers to craft laws, but we'll set that aside. What happened in the case was that there were the Secretary of Health and Human Services, in what was called the HHS mandate, required all businesses that provided health care to the employees to provide certain reproductive services, including providing access to contraception. And there were 4 contraceptives that the Green family objected to paying for. And they all were pharmaceuticals. In one case, it was actually a device that in some cases may result in the death of an early embryo. That is to say, after fertilization, before implantation, the embryo is destroyed as a consequence. Not every time, in fact, very rarely, but it's possible, and for that reason, the Green family objected to this. And the argument was, we believe, based on our deeply held religious beliefs, that embryos are in fact human persons and that we don't want to cooperate with their destruction. That was their argument. They went to the Supreme Court and they argued, not based on the First Amendment, but something called the Religious Freedom Restoration Act, which is something we'll talk about in a few minutes as well. And it was a federal statute that said that whenever a law substantially burdened somebody, the government had to prove that it was the only way to get whatever they wanted to get. In other words, they couldn't do it any other way. They had to burden these people. The Green family winds up winning 5-4 before the Supreme Court, based not on the First Amendment, but the Religious Freedom Restoration Act. But this is the important point, aside from the legal questions, is the way in which people tended to argue about this, both in the court and public opinion. 2 years ago, I was sitting down with some attorneys who were representing the Green family. And I told them that I didn't quite agree with the way in which they made their arguments in the public square. Not that I disagree with their legal arguments in court. Those arguments, actually, they had to make because lawyers, if any of you are lawyers or are going to go to law school, one thing you realize is that you can't be a philosopher in the courtroom. You have to just argue for your client based on law as it is, right? So, and they were doing that, and they did it well enough to win before the U.S. Supreme Court. But the way in which they would argue in the public square, they would say things like this: these are the deeply held religious beliefs of my client, it's their faith commitment, and so forth. Now, keep in mind the way in which our popular culture kind of categorizes these disagreements. So, you have on the one hand, reproductive health. Health is connected to medicine. Medicine is connected to science, and science is connected to reason, right? On the other side, it's deeply held religious beliefs. Religious beliefs are connected to faith. And so really the dispute is framed as what? A dispute between faith and reason. And so my criticism to the attorneys was this. I said, the reality is it's really not a dispute between faith and reason. Actually, it's a dispute between two different understandings of reason. On the one hand, you have many people, good people of goodwill, who say, I'm not convinced that an early embryo is in fact a human person, and they give you reasons for it. And the reasons are not scientific, they're philosophical. On the other hand, the Green family, although they believe that their theological tradition teaches this, they will offer contrary philosophical reasons for the opposite point of view. And so it turns out not to be a dispute between faith and reason. It turns out to be a dispute between two different sets of reasons about the nature of the human person. And so one of the issues that I think citizens in the United States have to face today is how are we going to frame our deep disagreements on issues like this? And the way in which it tends to be framed as, on the one side is detached, objective, secular reason, and that is obviously something that we should all embrace. On the other hand, it's faith, right? Reason, faith. You know, so it tends to be, this is this intellectually rigorous stuff over here, and you just have faith, right? And so, well, I'm going to explain later how we tended to, how I think we got here. But that's, I think, the best way to understand what's going on today. The response or the question by the gentleman in the audience kind of buys into that same understanding. In fact, the book I have that Ezra mentioned that's coming out actually in about a month, Taking Rights Seriously, is largely about how legal scholars in courts, I think, misrepresent the intellectual credentials of religious beliefs, and in fact lead us to think that these sorts of, that this is the right way to think about this question. In fact, in her dissenting opinion, Justice Ruth Bader Ginsburg, who I often disagree with, but I think makes a pretty good point in her dissent. She said that why is it the Green family gets a exemption under this generally applicable law, but why not, for example, the Christian Science business owner, and Christian scientists don't believe in medicine, right? Why can't the Christian Science business owner just get an exemption from paying for any health care, right? Or the Jehovah's Witness business owner who doesn't believe in blood transfusions, right? And her point was, why is this different? And the response by Justice Alito is, well, judges will figure that out by seeing whether there's a compelling state interest. Compelling state interest is just a fancy way for, at least I think so, some legal scholars would disagree with me on this, is a fancy way for judges to say, we're going to figure out what's reasonable. And the fact is, most people know someone like the Green family. Even though you may disagree with them, you know them, they may be reasonably intelligent, they hold this view. We really don't know people that don't believe in blood transfusions, a lot of us, right? And so part of it has to do with what people find to be plausible, and less with the actual text of statutes of the Constitution. At least that's my view on this. And this is why, you know, even though as I said, I oftentimes disagree with Justice Ginsburg, I think she actually makes a really interesting point, and it's one that I suggest in my forthcoming book, in a section where I deal with Ginsburg's dissent, that serious religious believers have to be prepared to defend the plausibility of their positions in the public square and not just rely on religious liberty. Because the fact is, courts are going to assess your claim based on what they consider to be generally plausible. So let's move on now to more history. You know, it'll be a kind of narrative of how we got here. I told you a little bit about what's going on, or at least the way I see the current landscape. But how do we get here? Another way to put it is, what does the separation of church and state mean? Well, everyone should know this, but the phrase separation of church and state is not in the Constitution, right? Well, and a lot of people point that out to sort of as a kind of rebuttal to the claim that there should be a separation of church and state. And although that's technically correct, I mean, one could make the argument that the First Amendment implies a separation of church and state, and I think that's reasonable to say. But the Constitution only mentions religion in two places. The one place it mentions it is in Article 6. What is Article 6? Article 6 is an article in the Constitution that prohibits a religious test for office, but only for the federal government. So, the federal government, the Congress, can't pass a law that says you have to be a Presbyterian to be president, or atheists are forbidden from running for office. They can't have that. But in the early American founding, I think 7 of the, maybe 10 of the 13 colonies, I know 7 of them actually had, or 6 of them had established churches. I think 7 or 8 of them actually had tests for office. And that is, you had to actually, in some places you had to just believe in God. In other places you had to be a Christian of some sort. In some places, Catholics and atheists were forbidden from running for office. So Article 6 is actually a compromise. You had people in the American founding that believed in an established church. They believed that the government should establish a religion. And what they meant by established church wasn't that everyone had to join the church, but that there would be a church that the government would favor in some way. So it would get your tax dollars. So we live in McClellan County, which has property tax, which is too high in my judgment. That's another issue altogether. And supposing, you know, 5% or 10% of your tax dollars went to the Methodists, right? Now, it couldn't go to the Baptists, because Baptists just by nature reject that. You know, in fact, if you find a Baptist that would accept that, he's probably not a real Baptist, right? But supposing 5% or 10% of your property taxes goes to the Methodists or the Congregationalists or the Presbyterians, and what does it mean, go to them? Well, it pays the salaries of the ministers and the upkeep of the churches and so forth. That's pretty much what established religion meant in the early founding. It wasn't that people, you know, that the Congregationalists would come to your door and say, convert or die. It was nothing like that. It was a kind of financial or economic burden on the part of non-members of that particular group. And so the belief was that religion at least that this particular denomination or group, by supporting that group, it advanced the common good. So it wasn't like the states or even people that wanted a federal established religion believed that other religions were necessarily bad. They just believed that their religion was the best and that it helped the public good by supporting it in some way. And so Article 6, ironically, was a compromise between those that believed no established churches at all, right? They didn't want federal or state, and those that wanted their state to have a established church, and they were afraid if the federal government had one, they'd lose theirs. So that's why Article 6 is kind of a compromise. Now, what about the First Amendment? The First Amendment, some of you can recite it by heart. I should be able to, but I can't. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the First Amendment, or at least portion of the First Amendment dealing with the issue of religion. There are two parts of it, or what are called two clauses, the Establishment Clause and the Free Exercise Clause. This also is a compromise. In the American founding, there were largely three factions. There were people that were called establishmentarians. They believed in an established church. There were people that were called dissenters, and then there were people that were called separationists. The dissenters were people like the Baptists. Well, what does that mean? Well, they believed that religion was a good thing, and that the government should not be hostile to it, that there was a governmental interest in making sure that churches were free institutions that flourished without any sort of coercion. So they didn't believe in an established religion, but they weren't separationists. Separationists were much stricter. They held the view that religion may be actually not very good. And you had people like Thomas Paine, right, and Thomas Jefferson that were a little bit more hostile to religion, right? And so one of the problems that the dissenters had, especially after the election of 1800, the election of 1800, you think the election of 2000 was controversial? The election of 18, you should have been there. No. The election of 1800 was between John Adams and Thomas Jefferson. Thomas Jefferson was a Democratic Republican. That was the early name of the Democratic Party. And John Adams was a Federalist. And the Federalist preachers were all over the country preaching against who? Thomas Jefferson. Right? And they were saying things like, we cannot elect this infidel, Mr. Jefferson. And so, when Jefferson gets into office, guess what? He's no friend of religion, right? And he's not really a friend intellectually. I know he authored the Declaration of Independence, and there's, he does just explicitly state that our rights are grounded in God. But understand, for Jefferson, his religion was largely a philosophical matter. It wasn't an ecclesial matter. He was a deist. He believed that God created the universe and that our rights were endowed to us by God. But things like special revelation or liturgical ceremonies or anything like that was not on the radar for Jefferson. He actually put together a Bible, so to speak, where he cut out the miracles of the New Testament. He didn't believe such things happened. So, in 1802, there's a group of Baptists, the Danbury Baptists, and they write Thomas Jefferson a letter. Why did they write him a letter? Well, they're in Connecticut, and Connecticut has an established church. It's Congregationalism. And they write Jefferson a letter, and he says to them, they complain. They go, look, please do something for our state. And of course, at that time, the federal government really didn't interfere that much with the powers of the states. And so Jefferson writes a response to the Danbury Baptists, a very famous letter called A Letter to the Danbury Baptists. And he says, believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legislative powers of government reach actions only and not opinions. I contemplate the sovereign reverence, that act of the whole American people, which declared that their legislature should, quote, make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. Now, what he's saying is this. He says, the First Amendment is in the federal Constitution. It doesn't apply to the states. I hope your state eventually passes something like that, but I really can't do anything. Right? Now, that sounds kind of odd to us today. How did the First Amendment get applied to the states? And that's an interesting story that I'll just make a little segue about that. In 1868, the federal government, Congress, and the President passed what becomes the 14th Amendment of the Constitution. It's one of the several post-Civil War amendments to protect former slaves. And there's a passage in there which says that nobody's life, liberty, or property shall be taken from them without due process of law. There's also an equal protection clause, which is modeled after the Fifth Amendment, that many of us are familiar with. Now, why is that phrase important for the First Amendment? Well, towards the beginning, or actually the beginning of the 20th century and then onward, the Supreme Court starts saying that that little clause that says life, liberty, or property, that term liberty, they start saying something like this. Well, that liberty includes not only the liberties that those citizens have as citizens of that state, it also includes the liberties they have in relation to the federal government. And so what the Supreme Court begins doing is incorporating the Bill of Rights through the states, or through the 14th Amendment to the states. And actually, it's not until 1947, this actually surprises my students at Baylor when I tell them this, it's not until 1947 that the Establishment Clause is applied to the states. And you think, you mean before that, the states could have an established religion? Absolutely. In fact, it wasn't until the 1820s that the last state quit having an established religion. And the case that the Supreme Court issued, in which it incorporated the Establishment Clause, was a case called Everson versus City of Ewing. And it involved a reimbursement for school busing to parents that sent their kids to parochial schools. And what makes it a significant case historically is not only that it was the first time the Supreme Court incorporated the Establishment Clause, it was the justice that issued it, Justice Hugo Black. Justice Hugo Black was, before he was appointed to the U.S. Supreme Court, was a member of the Ku Klux Klan, which was notable for not only its views on race, but also on religion, in particular Catholicism. And so one of the groups that was very much opposed to black being on the court was American Catholics. And so when this case came to him, it was an opportunity for him to do something for the Catholics, but at the same time incorporate the Establishment Clause. What does that mean? Well, in the case, virtually all the schools were Catholic schools. And so this way, what he did is he argued this way. He said, well, reimbursement for busing is sort of like a public service, right? Like let's say, the fire department. No one's going to say the fire department shouldn't put out a fire in a church because of separation of church and state. So in the same way, all that we're doing here is kind of reimbursing people for a public utility that we're giving free to public school children. And a lot of his strict separationist friends were really mad at him because they said, this is a violation of separation of church and state. But he was a lot shrewder than they were. He was able to change the trajectory of church-state jurisprudence in such a way that today we don't even think anything of applying the Establishment Clause to the states. But prior to 1947, very few people made that argument. In fact, on the Supreme Court right now, there's only one justice that actually doesn't believe in incorporation in terms of the Establishment Clause, and that is Justice Clarence Thomas. Although he thinks you can get everything out of the Free Exercise Clause you can get out of establishment. So he has an interesting theory. His theory is that you can only, the rights clause in the 14th Amendment that says life, liberty, and property, since the Establishment Clause is a limit on the power of the government, it's not really a right. You can't incorporate it because you can only incorporate rights. It's actually quite a clever argument, but he's the only justice that holds that view today. In any event, the First Amendment, as it was originally crafted, was a limit on Congress's power. It wasn't a limit. It says Congress shall not, right? It doesn't say the president shall not, right? In fact, for that reason, presidents, up until the present day, use theological language and issue proclamations and actually use money from the executive branch for religious things all the time, right? In the 1990s, President Clinton. You guys mentioned President. Who mentioned President Clinton earlier? Or Ezra did. I just want to say one thing. I got to do my Clinton impression. I'm just delighted to be here. You know, whenever I board an aircraft, I touch it and I say, I feel your plane. All right. All right, that's it for Clinton. But President Clinton signed into law something called the Office of Faith-Based. Actually, he may have not signed. It might have actually been an executive order. The Office of Faith-Based Initiatives, which is totally under the discretion of the executive branch. And every president since Clinton, including George Bush and Barack Obama, have funded it. And basically, the money is discretionary to give to what they think are important charitable religious organizations. And it's been challenged, but the Supreme Court actually just chose not to deal with it. Very interesting case. So there is still a kind of understanding that, at least in terms of the federal government, that the president has some discretion. And of course, he doesn't have ultimately the purse strings. Congress could actually cut it off if they wanted to. But the reality is it does say Congress, right? And eventually it gets applied to all governments in the United States, including state governments and local governments as well. So what happens after this slogan, the separation of church and state, enters American vocabulary? Well, it pretty much stays, there really isn't much talk about it until the 1860s, maybe 1840s, 1850s, 1860s. What happens during that time? Well, the United States begins accepting large groups of immigrants, Irish, German, Italian immigrants. Many of them, some of them move to places like Texas, right? We have the descendants that live in a city called Dublin, Texas. You ever drive through Dublin, Texas? Just take Highway 6 all the way. It takes you all the way to Santa Rosa, New Mexico. I drove with my nephew all the way to Santa Rosa, New Mexico, up 6, and we went through Dublin. And they're very proud of their Irish ancestry. Italy, Texas. Where do you think that came from? Many of the Italians that moved to the United States, moved to San Francisco, were more familiar with the sort of Ellis Island immigrants, right? Those that came to America late 19th century, early 20th century. But there was a large group, Italian, Irish, German, in the middle of the 19th century, and most of them were Catholic. And they wanted to set up their own schools, and there was a real resistance to this. America, after what was called the Second Great Revival, was largely Protestant. And there was a perceived threat. Most of the public schools, which were called common schools at the time, were kind of part of, they were public schools, but they were largely locally run, and there was Bible reading and prayer. And obviously there was resistance to the German, Irish, and Italian immigrants starting their own common schools that were going to teach things that were, in the judgment of a lot of people, anti-American. And so arose at this time was a movement which was personified in a congressman from Maine named Blaine. If he became president, you could say Blaine from Maine reigned, I guess. In any event, Congressman Blaine proposed something called a Blaine Amendment that actually was going to put in the federal Constitution a prohibition against the use of any government funding to any quote-unquote sectarian group. And it failed actually by one vote. It would have made the Constitution. Now today, the Supreme Court, some members of the Supreme Court interpret the First Amendment to be a kind of equivalent to the Blaine Amendment, and other justices don't. So there's a kind of dispute right now in the Supreme Court about how much a government can, let's say, fund a private religious school through vouchers. Right now, the majority says yes, but it has to be very careful in terms of what particular programs they fund, that it doesn't fund anything explicitly religious. So even though the Blaine Amendment didn't pass, there's still many people in this country, including some justices, who believe that the First Amendment should be applied strictly to include what the Blaine Amendment failed to do, namely to prohibit any sort of funding. And this actually is a good time to kind of tell you the difference between two different types of separationists in our contemporary American scene. Most people, in fact, anybody you run into in the United States, and there are very few people who would actually say they aren't a separationist. Everybody will say, I believe in the separation of church and state. But like anything, any debate, any discussion, or any particular phrase at a high level of abstraction, when you get into the weeds, that's when people disagree. So when you say, I believe in the separation of church and state, to some people that means a kind of strong separationism. Now what is strong separationism? I'll give you what I think is a good definition of strong separationism. Well, let me just say what they have in common, the strong and moderate separationism. Both of them affirm that the government should maximize religious liberty consistent with the public good, as well as prohibit both ecclesiastical control of government powers and government control of ecclesiastical powers. So both sides say the church, in the sense of religious bodies, and the state have their own separate functions and order and their own authority. Right? In fact, if you read the American founders, all of them, even those that believed in some form of establishmentarianism, in fact, everyone who believed in an established church still held to a very strong view of religious liberty. Well, how can that be? Well, they made you pay for the Congregationalist church, but they didn't make you attend it. That's how there was an understanding that to have an established church was not the same as forbidding one from exercising religious liberty. So both sides agreed that the church and the state were not the same thing. Again, the founders would use language like this. They thought of a person's religious commitment as being under the obedience of another sovereign. So the reason why you, let's say if you're a Quaker, and you are pacifist, and you will not fight for General Washington in the American Revolution. People at the time didn't see Quakers as individuals that just didn't want to go to war. They saw them as people that couldn't go to war. That is, Quakers were thought of as citizens that couldn't. It wasn't that they just chose not to, but that they felt that God was telling them they couldn't do it. And this is an important point, comparing it to the way people think about religion today. People tend to think of religion today, generally, as a kind of commodity. Like, you're going to the supermarket, you're at H-E-B, and you say, I bought some Buddhism today. I think I'm going to get some Hinduism. There's a sense in which we think of at least generally, people tend to think about beliefs as things that you choose. And the reality is, most of our beliefs we don't choose. Right? You try unbelieving something. Think about it. Like, right now, I know that I'm appeared to by an audience. Right? How can I unbelieve that? Right? I could close my eyes and say you're not there, but I kind of know you're still there. Right? Now, for most people who have deep religious convictions, that's how their convictions are. It's not that the Quaker goes, well, I choose to be a pacifist. No, I can't help being a pacifist. If I deny it, my conscience will bother me. Right? And conscience isn't just some kind of instinct. It's something that is deep in one's soul. And that's the way the founders thought about it. And that's why they carved out exemptions for Quakers. right? They accommodated them. Now, eventually it became a federal law, not until the beginning of the 20th century. But the military did not go out of its way to try to force Quakers to fight, right? So, getting back to the distinction between the separationisms, they both agree, both moderate and strong agree, that the church and state are different, and they have different roles, and that there are different sort of lines of authority, right? But the moderate separationist is a little different, and I'll tell you a difference between something about the strong separationist that differs from the moderate. The moderate separationist does not attempt to exclude religion from public life, and thus would, for example, support public funding programs for similarly situated religious and secular entities. So, to give you an example, the moderate separationist would, let's say, look at a voucher program that gives, let's say, tax dollars to parents to choose whatever private school they want for their children, and supposing the law excluded religious schools. The moderate separationists would say that's unfair because you're actually burdening religion. Whereas the strong separationists would say, no, you're not burdening religion. What you're doing there is you're getting the state out of religion, and in fact, if you gave money to the religion, you'd be burdening the taxpayer who holds a different religion. So you have like two different paradigms in how you look at the distribution of those resources, right? So the strong separationist not only has a kind of economic view, that is to say, he doesn't believe any funding should be used. He also it wants to exclude political proposals of religious citizens if those proposals are religiously motivated. Though similarly situated non-religious citizens who offer proposals based on secular grounds are unlikely to face a kind of pushback. So to go back to the illustration I began with in the Hobby Lobby case, there's a tendency to interpret what I think, at least in terms of this kind of strong separationist today, what are really two different positions on the same subject as two different subjects. So in the Hobby Lobby case, the dispute, at least the way I see it, is on the one hand you have one set of citizens who believe that embryos are full-fledged members of the human community and they ought to be protected, and at least they don't want to be forced to participate in their destruction, whereas the other side doesn't see it as that question at all. They see it as that it's a religious issue, and that science is in fact on their side. They see it as two different subjects, religion versus science or faith versus reason, whereas others will see it as, no, it's really a dispute between two different positions on the same subject, right? And I think a lot of issues are like this, where, and this is why, again, I began with the comment by the gentleman in the audience at Texas Tech. By putting the adjective religion in front of my arguments, it somehow diminished their significance, right? They weren't really rational in any way. So, let me just say a few concluding remarks. There's lots of things I could talk about, but I'd like to open up for some questions. I want to say a few things about the challenges today. That is, not only the ones that I've mentioned, but what I see on the horizon. In the law review literature right now, and I talk about this extensively in my forthcoming book, there are two questions that are coming out in the literature that I think anyone who's interested in church and state, religion and politics should be interested in. And that is, one question is this: what is religion and is it special? What is religion and is it special? Now, that sounds like an odd question because you can always think of like paradigm cases of religion, right? Like Christianity, Judaism, Hinduism, Buddhism. But once you start trying to define religion, it becomes really tough, right? If you say, well, a religion, you have to believe in God. Well, certain Buddhists don't believe in God. Are they religious, right? Or belief in an afterlife? Well, you know, the ancient Greeks or the ancient Greek religion didn't believe in an afterlife. Is that not religion, right? Or how about being part of a church, right? Well, what if somebody they're the only person on earth with that religious belief, Are they not entitled to liberty? Right? Or going back to some of the issues that I brought up earlier. You know, there are some people who would agree with me on the way in which I presented, let's say, the Hobby Lobby case. I have friends who disagree with me on other questions, but will say to me, you're right, Beckwith. It is a dispute between two different opinions about the same subject. It's not between like religion and secularism. It's actually between two different philosophical understandings. And for that reason, religion isn't special. So they kind of take it the other way. So now the other is another sort of tactic or way of looking at this is some philosophers have raised this question, including University of Chicago law professor Brian Leiter. In fact, in my forthcoming book, I have a chapter, most of which deals with Leiter's work. And Professor Leiter argues that religious beliefs should receive no special protections or accommodations since religious beliefs are fundamentally irrational. That they should be treated as no different than other sort of positions on matters of taste. And, you know, so you may like to go see the Rolling Stones in concert, and I may like to go to church on Sunday, but it doesn't matter. The religion is just simply a subjective opinion about the universe that's different from, let's say, rational disciplines like the hard sciences. And that's the way Leiter thinks on this. And finally, something I've already alluded to, what about issues of equality and accommodation? So if one does not believe in giving religion any special treatment, for example, then what about just treating religion equally? Right, which is what Leiter suggests. But that brings up problems. So we tend to, let's say, thinking about going back again to the Hobby Lobby case. Supposing we want to treat, supposing you treat religion equally, right? That would mean that the opinion of the owners of Hobby Lobby should be treated just with as much respect as, let's say, someone who has an opposite point of view. But what about the voucher cases, right? So in the voucher cases, or the case of vouchers, if you're a strong separationist, you kind of have to exclude religion, right? But that's not treating religion equally. In other words, it's not treating private religious schools on the same footing as private secular schools. So if one holds that religion shouldn't be treated special, then it follows that if it shouldn't be treated special, it shouldn't be targeted for exclusion either, right? So that's a problem. And then what about moral questions? Like, I mean, the abortion one is one in which, you know, people will, you know, strongly disagree. But think about the cases of, let's say, a physician who is required to, we think about the physician at his hospital required, let's say, to not only perform an abortion, but maybe, let's say, refer a patient to a physician that can perform that, and the physician refuses to do it, right? And appeals to his religious liberty, supposing it's a state-owned hospital. A lot of people are kind of divided on that, right? Most people will say, no, he shouldn't be forced to perform it, but then you'll have people divided on whether the referral counts as cooperation. But let's pick another case. What about a capital punishment case, right? Imagine you have a physician that is works at a hospital and is one of the only physicians on duty to, let's say, perform the lethal injection. Should that physician have a right to, as a matter of conscience, let's say he opposes the death penalty as a matter of morality, not engage in it, right? So these are the issues that are, I think, on the horizon. Let me just repeat them. It says, what is religion and is it special? Is religion rational? And then the question of equality and accommodation. So let me open up the floor for any questions you may have.
Okay, we're going to start Q&A. I'm going to check real quick. Eddie, Amos, are we still taking tips? Still taking tips. All right. The way Q&A runs, we have a microphone right there. I simply ask that your question is 2 minutes or less. We have a lot of questions that are submitted online. So if you have a question, just stand right there and we'll get to it. First question on the line. As people who are called to submit to governing authorities, how should we think about a country that is founded upon rebellion against those very same authorities?
That's a great question. So I suspect the person wants me to give a moral argument for the American Revolution, and I'm not going to do that. Let me put it this way. This is going to sound really controversial, so I guess I may as well say it. I'm not sure the American Revolution was morally justified, but but that's a question for another topic or another time.
The First Amendment says nothing about separation of church and state or a wall of separation between church and state. Where did this idea come from? Is it really part of law?
Yeah. It came from Thomas Jefferson. Actually, originally, Jefferson picks it up from other thinkers that preceded him. It's an idea that has been around for quite some time, but it isn't in the Constitution. In a way, I mean, a good way to look at it, it's more of a shorthand way for people to describe and present their understanding of the relationship between church and state. So, yeah, it's not in the Constitution. I don't mind using the phrase, but I do think that if we're going to talk about the relationship between church and state, merely using the slogan doesn't really work. You have to actually get into the weeds, so to speak. Actually, if I'm mistaken, I think it was Roger Williams who first used the phrase. If I'm not, I could be wrong about that.
Question submitted online. Is it constitutional to teach about religion in a public school?
It is constitutional. You can teach about religion, but you just can't. At least as the Supreme Court interprets it, you simply can't, teach religion, one religion as the correct one. You can't indoctrinate people.
How or should the Bible be included in the history curriculum?
It's a great question. And there's several ways the Bible can be included. First off, let's say, for example, a course on the history of literature. I mean, you can't actually understand most of the great works of literature without understanding Scripture. You can't understand the debates, historical debates, everything from the relationship between the Roman Empire and its peoples to the debates in the Reformation, even at the debates in the American founding. So I think Scripture can be taught in terms of what people actually believed. Now, I'm not sure if the person's asking, how do you teach Scripture as an historical document? That's a different question, and the fact is that if somebody were to propose it as such, it would be highly controversial, to be sure. But in a way, it seems to me that it wouldn't be such a bad thing for us to have a public conversation on that very question. But if in fact a school is going to teach history, I don't think there's any way you can teach American history, let alone world history, without dealing with Scripture. I mean, think about the disputes that we've had in American history, everything going back to the American founding, the disputes, by the way, about the Revolutionary War, all the way to the debates about slavery, to the Civil Rights Movement, even women's suffrage. I mean, all these have a theological and biblical component. I don't think you can actually talk about these things without knowing what people believed, and virtually everyone involved with those disputes often appealed to Scriptures, and sometimes, contrary accounts.
What did the courts say about the Bible in a public school curriculum?
You can teach the Bible. I mean, there's no doubt about that. Several justices have, in some very famous cases, including one of the early prayer cases in which there was a required recitation of Scripture over the intercom in New York State. And one of the points made by one of the justices, and I forget which one said this, that clearly you can study the Bible, but there's nothing, it's perfectly permissible to have it in the library, for example, but it just can't be taught as an authoritative religious or theological document.
Okay, what about some of the school districts that are teaching the Quran, but will not include the Bible?
Yeah, well, they certainly, I think, under the Constitution, do that if they do it in a way that's simply to teach students what people believe. It would be certainly permissible. Now, having said that, though, clearly it would violate the Constitution if a public school were to teach the Quran as an authoritative religious document that students ought to obey or follow. So, I mean, it seems to me that if you have a school district that offers a course on understanding Islam and requires students to read the Quran, well, it seems to me that there's nothing impermissible in having a course in which students are, a course, let's say, on understanding Christianity or Judaism and teaching Scripture. I mean, that's perfectly permissible under the Constitution. What can't be done is teaching it as if it's authoritative and true. That's what the courts have concluded.
Dr. Beckwith, my question has to do with your view on how strong the separation of church and state as a policy will hold in coming years. I believe there's a fear right now on one side that certain changes recently and debates on equality and the sort will lead to perhaps the state pressuring churches to give in to same-sex marriage or the sort, or perhaps lose their tax benefits as not-for-profits. On the other hand, you have a fear that the sort of resurgence perhaps of religious liberty is going to allow religious right to perhaps trample all over people's liberties. So there's these fears that the separation is kind of falling apart maybe or being abused. Do you think that in general it's going to hold in a fair and balanced way, or do you think it's starting to slant one way or the other?
Yeah, that's a really good question. I mean, I'm neither a prophet nor the son of a prophet, so I'm not going to offer any predictions. I do think one of the reasons why the issues tend to be so different today is that people are divided on deeper questions, and let's say the people that were divided let's say in the 1940s or 50s, or even in the early American founding. Let me give you an example. The United States could tolerate or allow accommodations for Quakers and let's say Mennonites and Amish. For a couple of reasons. One, there weren't a lot of them, right? And so they didn't want to participate in war, and they were accommodated. And also, a vast majority of Americans at the time, and even today, associate in some way to Christianity. And so even though they may be Presbyterians or Catholic or Baptist, and even though they may think that the Amish, the Quakers, and the Mennonites are really off base on their pacifism, they still thought, well, those people are kind of still within, there's still a shared cultural framework. Now, the Mormons are a different story, right? What happens in the 1850s through the 70s? Federal government passes legislation forbidding pornography, forbidding polygamy, the P word, forbidding polygamy, right? And now you think, here's a case where you have a religious group that is practicing polygamy. In fact, they're not just practicing it, they got quite good at it. It's a joke. So they're practicing polygamy, right? And they're doing it because of religious sanction. They're saying that God told them to, right? So guess what? Congress, which has authority over territories, Utah was not a state yet, could pass legislation that actually could target the free exercise of religion, right? I mean, here was a case where we actually had the federal government passing a law saying polygamy is prohibited, and the Supreme Court, in a unanimous opinion, upheld the statute. Why? It's because Americans just thought that was a bridge too far. that it was that this was, in fact, in the majority opinion, the justice that writes it says, the occasion of this legislation is the fact that it's a religious group practicing it, but polygamy is the practice of barbarians, and we're a civilized race. And then he goes on to say, and actually it's interesting that this is in the opinion, he says that polygamy leads to the principle of patriarchy. That is, what happens is that in polygamous cultures, one man, many wives, that sort of creates kind of tribalisms, and that's inconsistent with liberal democracy. So the two arguments that the court uses to uphold the federal statute, which was specifically there to target a religion. Why is it that why don't Mormons get the free exercise? Why don't Mormons get accommodation like the others? It's because the cultural disagreements were far too deep. So the question that I have in terms of the future, and a lot of these issues, one of which you raised about the issue of marriage, can we do it? Can we pull it off in America where we can have a disagreement of that depth and at the same time allow accommodations of equal depth? And that's going to be tough because those other accommodations always took place within a much more common culture. So, and that's that. And I want to plug my book again, but actually the last chapter deals with that very issue. So.
It seems that historically we've been moving towards a more separatist stance as a nation. If we continue to progress and we get to a point where it's more like absolutely intolerable to express yourself religiously in any state, building or workplace, what would that mean for 21st century or future century evangelism in those type of settings?
It's a great question. You know, Jesus said to be wise as serpents and as gentle as doves. And so if that were to happen, I mean, Christians and other religious believers, supposing it was, obviously applied to all religious believers, would have to be circumspect in the way in which they conduct their affairs, right? That doesn't mean you compromise or don't preach. You have to, do like the early church did, right? Use the resources at your disposal. You may have to not say anything at work, but work isn't the government, right? So the difficulty is going to be if the government tries to shut down a church, right? Or actually prohibits preaching from the pulpit. That's going to involve a lot of courage on the part of people that resist that. In some ways, I think one of the things we also have to think about, and here I'm talking as a Christian, is we have to shore up our own institutions. And that means that there may come a time, and of course I don't know whether such a time will come or not, but if such a time were to come, we have to think about how we're going to form our own people. That is to say, how are we going to educate Christians? What sorts of institutions that we can create that can survive, that will allow us to propagate the faith not only in the present but to future generations. And those are questions that other generations of Christians and even Christians in other parts of the world are dealing with right now. In fact, last Friday of the 18th of September, I participated at this conference on religious liberty that was held at Catholic University of America. It was actually sponsored by Baylor, Catholic U, and Georgetown University. And I had the opportunity to listen to two Syrian Christians and a Christian from China give their testimonies about what happened to them there and the sorts of persecution, in some case actual physical violence. In one case, the woman from China was tortured. And to listen to this, and to see their faith, it was remarkable. And I felt kind of guilty, thinking, I don't think enough about these people. And of course, in some future date, we could be these people, right? But it really, one of the things that she shared was how, the woman from China, how much, she had a spirituality and a depth to her prayer life that was just astonishing. When she was sitting there, she almost had a halo. You had that, and that's, so, we have to think as American Christians, how are we going to conduct our lives, just not in terms of what the government's going to do, but how are we going to live? How are we going to be holy? And that's tough, right? So.
Question online. Could you address the First Amendment rights versus the 14th Amendment rights of the Bakers in Colorado and Oregon?
Okay, it's a good question. Those cases involving bakers and the florists, and there's also a photographer case in New Mexico. Those are cases in which you had same-sex couples come to those establishments and ask them to perform their services either before, after, or during the wedding ceremony. And in each of those cases, I think in court, all the cases in court, they lost. The way I understand those cases, and I'll give you, this is, again, it's going to be in my book in a month. I have a section dealing with these sorts of cases. I think the right way to look at these cases is that they are not, you can't look at these family-held businesses, especially these small mom and pop operations, which they are, as somehow impersonal businesses. These are individual persons that have deep convictions about their religious beliefs and who also think of marriage in a liturgical way. What does that mean? They think of marriage or a wedding as a kind of important, not just an important milestone in one's life, but something that distinctly honors God. Now, as a Catholic, I believe it's a sacrament. Other Christians believe it's a sacrament. Some refer to it as an ordinance. But in any event, it has a deep and important aspect, at least to the Christian faith. In Scripture, it says that the church is the bride of Christ. So even the analogy between Christ and his church involves marriage. And so to ask somebody, so for me, so when I look at these cases, I look at it as citizens being asked to cooperate with a liturgical event that they believe is not authentic according to the way in which they think about their theology. I think it's a mistake to look at these cases as cases of discrimination based on sexual orientation. That's the way it's framed in the media. In fact, one of the arguments that one of the attorneys used in the New Mexico case, which is an argument that I've defended, I think it's a great argument, but the court rejected it. So sometimes you can have great arguments because courts reject it, or the court could reject it because maybe it really isn't a great argument. But this is the argument that the lawyer used. He said, look, my client would not agree to photograph a same-sex ceremony even if both participants were actors simply replicating it on a movie set and they were both heterosexual. In other words, it was the nature of the ceremony that was at issue, not the sexual orientations of the participants. And to me, this is what I argue in my book, that if you look at the way in which we kind of categorize our lives, right? We have baptisms, burials, bar mitzvahs, and weddings, right? I mean, those are the sort of the things that we think about. These are the most important. And for most people, these events are tightly tethered to our theological traditions. And so to kind of, and some people may disagree with me. I know lots of people may disagree with me on this. But to sort of make it sound as if these are kind of mean, nasty businesses, and not really taking into consideration the rich theological traditions from which these people come, I think does a disservice to the sort of dialogue that has to occur for us to sort of get to the point where we can understand that such accommodations, I think, do make sense.
Yeah, so my question is one about dialogue. It's about how we use language. My question is, what happens whenever the words you use don't mean the same things? So a kind of polarization occurs whenever you say the same word but it doesn't mean the same thing. So I'm thinking of terms like marriage or family or liberty, one of the words, so life, liberty, the pursuit of happiness. What happens in a culture, and how would you describe this certain sort of legal situation of words not meaning the same things to the same people? And how do you kind of recover a sense of consensus, which you need to have a rule of law or idea of the common good, maybe? So how do you, when we don't mean the same thing, we miss each other. How would you describe the sort of legal understanding of that issue?
How do you respond to that? That's a tough question. I don't know how to resolve it. I mean, I do think you're right that when we use language, oftentimes we sometimes think the other person means the same thing. I do think in terms of dialogue, allowing people to be able to defend their definitions is important. That is, so supposing, this is actually an illustration, an article I published a year and a half ago, and it's based on something I do at Baylor in my class when we go over the marriage issue. I asked my students, is there a difference between the question, what is marriage and how do we define marriage? And they typically say, no, there's no difference. And I get them to, at least I think I get them to see that there are actually two different questions. If I say, for example, what is a human being? That's different than saying how you define a human being. So if I like a typical Aristotelian definition, I say a human being is a rational animal. But then you follow up, well, how do you define human being? I'd say, well, no, I believe a human being is a rational animal. The definition I have is really a definition that I've acquired because I think it actually corresponds to reality, right? But there's this other kind of way of thinking that definitions about natural things or apparently natural things is really a matter of just kind of human will. And so this is a kind of ancient debate between the realists and the nominalists. And it's coming out in the marriage debate, I think. You have one school of thought that says that no, things have real natures, and marriage is a sort of institution that arises from the nature of men and women, right? It's not to say that other sorts of relationships aren't friendships, but they're just not marriages, right? On the other hand, there's another school of thought that says, no, marriage is a kind of social convention, and over the years, marriage has actually changed a little bit, right? Beginning with no-fault divorce and open marriages, permanence and exclusivity have gone by the wayside. The only thing left is conjugality. Why is that important? So I would say it's not really so much a debate between two different ways in which people use words. I think it has to do with the nature of words. In other words, our concepts. Do our concepts really, are they descriptive of a reality out there, or are they simply under our will? And I think you mentioned liberty. I think it's a really important import for how we think of liberty. Let me give you an argument that's used by people, or it was used by Justice Ginsburg in her dissent, not the one that I mentioned earlier, but another one. She said that the reason why Hobby Lobby shouldn't get an exemption is because it would result in third-party harms. That is, the women who work for Hobby Lobby who would be denied access, or at least monetary compensation for those 4 contraception devices and pharmaceuticals out of 20 would be burdened. And so since this involves third-party burdens, this is why they shouldn't get an exemption. But think about how, that's an unusual argument, because basically those employees are not parties to the suit. They don't have standing, technically, right? But the other thing, it'd be kind of, what if the government, let's say tomorrow, passed a law that said everybody with 2 eyes has to give one of their good eyes to someone who's blind? And you said, that violates my rights. You go, well, now if you ask for the government to exempt you from that, that's a burden, because that blind person now will not get that one eye. He said, well, wait a second. The debate is about the initial question of liberty. So there's just an unusual, I just frankly don't understand Ginsburg's argument. I just think but I do think there's something else going on there, a kind of, a definition of liberty that it's not merely the constraint or the government constraining itself from coercing you. It's that you're denied something that you desire, which is not the same thing, right? Because the city of Waco may deny me a Corvette, but that doesn't mean that somehow my rights are violated, right? But if you, let's say, steal my Corvette and I want it back, my point is that it's just these questions about liberty, I think, also have to, you said at the very end of your question, you mentioned liberty, but I do think there's the same conceptual issues there as well.
So Dr. Beckwith, my question kind of piggybacks off that distinction that you just drew between nominalism and realism. So when the separation of church and state is invoked, it's not necessarily churches, Christian specific churches, that I think are the ones in mind. It's rather a certain type of Christian church that holds nominalist beliefs, therefore obligatory beliefs on other people's that impinge upon autonomy. So from 1970 till now, the debates between church and state have revolved around abortion, same-sex marriage, contraception. And that derives from a realist vision of nature. And so my question is, what is it really a separation of church and state, or is it just a separation of churches that hold beliefs that, or hold realist beliefs that thus impinge upon other people's autonomies, or autonomous natures and autonomous desires, that is really in play? And certain other types of Christianity or certain other types of churches, ones that are more spiritual, personal, and non-obligatory, are okay. Kind of this freedom of exercise and freedom of worship distinction.
Yeah, I think there's something to that. I think that that given the nature of the issues over which we disagree today, they tend to be deeply philosophical disagreements, and it turns out that, you know, certain churches are more connected to certain sides of those issues than others, and that's why at the very beginning I wanted to frame our contemporary situation is really not a dispute about religion versus like reason, but really two different rival accounts of reason. And you know, why is that? I think part of it, and here I want to be fair to people that disagree with me on this, because a lot of people that I read, I think it's that they just haven't, you know, what's the right word? They just are not really aware that people actually have, at least I think, good philosophical reasons for holding the views they do. So, so I have one article that named by a professor at Cornell Law School, Sherry Cole, who I respond to in my book. She's talking about the embryonic stem cell research debate in the early 2000s, and she says, you know, you have every right to believe when you think the soul, you know, arises in a human being, but that's a theological question, not a scientific one. And so one of my criticisms is that actually the question of the soul is neither scientific nor religious technically. It's actually a philosophical question, and it's one that can't be answered by the hard sciences. So yeah, I mean, I think one of the, hopefully, you know, if we think more clearly about these questions, I think we should come to the conclusion that we can't sort of resolve it by a kind of trotting out the old, we just got to separate church and state. I mean, it's going to be, you know, it's easy in one way to do that, right? Because it turns out that, you know, most people who hold these views are in fact religious believers of one sort or another. But it turns out, though, that both sides on these issues actually are answering it from different philosophical vantage points. So.
Questions submitted online? Check. No? Charles asked, would you comment on whether someone with a commitment to Sharia could uphold the U.S. Constitution?
That's a good question. I am not an expert in Sharia law, and I don't know a lot about it. So I'm going to punt on that question. I'm not an expert in Islam. In fact, it's one of the areas that I don't know a lot about. So I will tell you, though, that I think we have to be careful in any laws that try to, in any way, say that, try to restrict Sharia, and this is why. I think it could be used against Christians. So, for example, imagine, let's say a divorce case occurs, let's say between two people who are Presbyterians, and they go to a court of law, and in their arguments, let's say one side appeals to the internal laws of the Presbyterian Church USA about how proper divorces should occur. It seems to me that that people should be allowed to make those sorts of arguments in court. So again, I don't know enough about Sharia law. I'm not an expert on it, but I do think we have to, especially those who are not part of a minority faith like Islam, have to be careful that we don't put into the law principles that may get us what we want here, but in the long run may actually be used against us in the future. This is what happened with separationism. The separationists in the 19th century wound up using separationism to go after Catholic immigrants, and then it morphs into a kind of dogmatic secularism, and it's used against all Christians in the 20th century. So yeah, I think you have to be really careful about what principles you put in law.
So I was also going to ask a question about Sharia, but since you've said you're not real familiar with it, we'll just design a thought experiment about Bluriya instead of Sharia. Okay, so suppose there's this religion and its adherents follow Bluriya law, and Bluriya law forbids women's suffrage, commands the death penalty for apostates from this religion. You have things like female genital mutilation, etc., etc. The question that I want to ask goes back to something that you said in your talk, that when you have religion and you have government, these are two independent authorities. My question is, what do we do when the rights of one of these authoritative bodies are mutually exclusive to what this other independent authoritative body says we should and should not do? On your view, which one trumps? And I think this is an important question, because if you say, well, for Christianity, the church trumps, but for all other religions, it's U.S. Constitution trumps, you know, these kind of questions. I'm just curious how you might respond to that.
It's a great question, and I think, I'm going to go back now to the illustration I used with comparing the Mormons to the Mennonites and the Amish and the Quakers. I'm not sure you can have a regime like the United States without a common culture. I'm not sure you can have a regime like the United States without a common culture. And because at the end of the day, the law is going to reflect some moral understanding, right? And so by its very nature, it's going to exclude certain sorts of practices as beyond the pale. This is, by the way, in the Reynolds case, which is the case that upheld the prohibition of polygamy, one of the illustrations on the part of the justice that wrote it was, look, we're not going to allow people to sacrifice their children, you know, to Baal and, you know, under religious liberty. So at some point, I think you have to have a common culture that accepts certain moral truths. And that's why I raised the question when the issue of marriage came up, whether you can, how deep and how divisive can you go, and at the same time have a common culture. And I'm not sure I don't think there's an answer to that other than saying that we have to get our hands dirty and make moral arguments. And I think that's, so there's no high abstraction, principled way of avoiding making the arguments. You know, and there's a tendency on the part of legal types, and I went to law school, I'm a legal type, to kind of come up with some general principle of law to resolve this. But a lot of times, general principles of law depend on prior understandings of what the good, the true, and the beautiful are. And so, but when the good, the true, and the beautiful are themselves contested, can you really have a civilization? And so the problem is you have two kind of contrary intuitions in our culture. One intuition is, and it's a good intuition, is that the United States of America is a pluralistic society that should be welcoming of people from all sorts of backgrounds, and I embrace that. It's part of, I think, what makes America great. But the irony is that people are drawn to this country because of the principles that the country embraces. And so, how much can you allow in terms of challenging those principles, in which the country itself becomes a different country? And so, I'm not, you know, I'm here. I'm just talking in the abstract. So. So yeah, I don't think you can actually answer that at some high level of abstraction. I think you actually have to get your hands dirty and make the moral arguments. So yeah, it's very difficult. I think it's a very difficult question, and the only way it's going to be answered is kind of in the rough and tumble of actual politics. Do you follow up?
No, it's a completely different question now. I just didn't see anybody else in line. So just to take the conversation in a slightly different direction, it seems that freedom of religion in the minds of many means freedom from religion. And I'm just curious, on what grounds do you think that atheists and agnostics understand themselves to be non-religious persons? I mean, on what principled sociological definition of religion do beliefs that cannot be scientifically verified of the non-existence of any supernatural deity provide grounds for us providing non-religious education in schools? Because, I mean, on my view, there's no escaping it. So even the science that is being taught in many ways is undergirded by philosophical presuppositions that are intuitive to many, but they're not scientifically verifiable. So if we're at intuitions versus intuitions, why would we allow non-religious, quote-unquote, education to dominate and be publicly funded, and deny public funding to religious education?
Yeah. Well, there's a kind of history behind it. The common schools begin in the 19th century. They kind of morph into the 20th century into government schools. And in most communities up until probably the 1960s, most public schools were just thought of as kind of the local community schools, and they often reflected the religious sensibilities of the people that lived in those communities. There were accommodations, to be sure. For example, even in New York State, where they had a required prayer, they actually allowed students to leave the room. There were accommodations for unbelievers or other religious believers that didn't feel comfortable with the prayer. So, but that changes. That changes in the 60s and 70s, and a kind of new principle kicks in, a principle of neutrality. And the principle of neutrality is the government school should not prefer one religion over another. But what happens is that education, like most things in life, has a moral component. Not only a component that deals with these ultimate questions that touch on science, but also how one ought to conduct one's life. What is the meaning of the good life? And the reality is, schools, in fact, do teach that, right? We had debates in the 60s, 70s, 80s, and even to the day about sex education, for example. Whenever you're talking about the question of the proper use of my sexual powers, that's a deeply religious question. That is, it has to do with who I believe I am as a person, how that's connected to my place as a father, a son, a husband, or whatever. And so when let's say the public schools, let's say on this issue, teach a particular view of human sexuality that is contrary to the lessons taught in Sunday school or at home, it is in fact not being neutral, but offering an alternative, right? So I think the way we kind of get back into the conversation is to make that point. The reality, though, is that those that don't want to go that way often will say that the mantle of science and reason is on their side. And I think we have to make the argument that, in fact, these debates are not about that. They're about questions of anthropology, philosophical anthropology. Who and what are we, and can we know it? So I think what's happened in terms of public education is that students, for example, have a right to express every aspect of their identity except for their religion, which actually is not how people, in fact, live their lives. It would be like, can you imagine if we told kids, when you go to school, you can't actually talk about where your family's from, or you can't talk about what your mom and dad do for a living. You can't talk about the Pop Warner football game. You can't talk about anything that you find to be important and interesting in your life. The world would be a really boring place. And I think to tell students, well, when it comes to religious beliefs, we're going to sequester you. Or you have to sequester those beliefs. Or tell parents, when you're before the school board and you make a case for, let's say, changing the curriculum to at least show respect for religious beliefs, you really have no place here. I mean, it seems to me that that is not the world that we should want to live in. And I think we become, I grew up in Las Vegas, Nevada. My wife and I both grew up in Las Vegas, Nevada. Actually, you don't really grow up in Las Vegas. You just kind of get older there. But it was a pretty, a pretty diverse community, right? I had friends from all different religious backgrounds. There were some kids that I knew that grew up in families whose parents were involved with businesses that I didn't know what they did, and the thing that you do in that kind of environment, you actually learn how to navigate even views that you might find repugnant, right? I mean, when somebody says, for example, my child shouldn't hear about this, you know, let's say one student sharing their faith. Oh, come on. It makes them a better person. I mean, I hear things, when I was in college, I went to college at a time in the late 70s, early 80s, when it was a much more interesting place. Professors didn't look over their shoulder to second guess themselves so as not to offend a student. They would say things, and most of the time they said things that did offend me, because I was a fairly, you know, traditional Christian at a university where most of the professors were hardline secularists, but they never disrespected me. And they said what they did, and I remember one professor, Randy Sheldon, who was one of my favorites. He was a Marxist, and he and I disagreed on everything. But I remember him saying in class, he goes, look, I'm here to get you guys to think, and I want you to disagree with me. And that was the kind of environment, that's the kind of background that really formed me. And so when I hear today about, you know, people wanting kind of an antiseptic environment and they want to sort of eliminate discussions, especially about religion, I think that's just, why would you want to live in a world like that? It's just kind of sad, you know? So.
Yeah, and kind of going along with that, it seems like the whole separation of church and state kind of evolved from the country not really wanting to address or stand on a specific principle in regards to religious preference, but rather kind of leave a veil of ambiguity almost. And now we're coming to a point that the country, even though it's founded on Judeo-Christian beliefs as really Christian undertones, is almost being forced to address issues that almost contradict those beliefs in many ways, and sometimes challenge previous legislation. So it's like it seems as if the country's being torn apart. So we're getting to a point, it seems, that we're going to have to stand for something. And as the gentleman said earlier, when you break away all the fancy names for a belief system, at the end of the day, it's a belief system. So which belief system should we cling to? Should we just say that, you know, because it's not a religious, that science should win the day and should be the prince of the air, or should we cling to our old tradition and then face the battles that we've been facing?
Yeah, yeah. It's you know, politics, like nature, abhors a vacuum. You can't, you know, any political regime is going to have some sets of assumptions about the good, the true, and the beautiful. I think in the way in which things are right now, I do think Christians and other believers of other faiths who are like-minded, I think, have to equip themselves to make the public argument. This is why I mentioned the Ruth Bader Ginsburg quote at the beginning of my lecture. She offers a challenge to Justice Alito, and the response by Alito, which of course as a justice this is the kind of response he has to give, is a legal argument appealing to the Religious Freedom Restoration Act, and that's fine. But I do think in terms of the public debate, you need more than just appealing to the law or saying, well, we have the First Amendment. No, justices and judges are influenced by cultural beliefs, and they're influenced by plausibility structures. That is, what people generally find to be plausible. And if you quit making the public argument, they're just going to think, well, you have nothing to your beliefs except for a kind of unreasonable faith. In fact, a discussion I had with those attorneys that I mentioned earlier, in the room with us was a clergyman who was one of the plaintiffs in the Hobby Lobby, or actually was a plaintiff in another case like Hobby Lobby, and he interceded in our dispute and said, I agree with Beckwith. He said, when we defend our belief that the early embryo is a human person, it's not like our belief in the Trinity. It's a different kind of belief. And I thought, yes, that's exactly what I'm saying. So we have to, on the one hand, understand, you know, what we believe and what sorts of beliefs we can defend in the public square.
Society as a whole has an incorrect view of the origin and meaning of separation of church and state. How do we effectively educate the American people on the true meaning?
How do we affect? What was the beginning of it? The question?
They have an incorrect view of the origin and meaning.
Yeah, I mean, most people Yeah, remember Jay Leno used to have that thing where he would jaywalking. He'd ask people things like he interviewed a bunch of students who graduated from USC. That's Southern California, not South Carolina. They asked them how many moons the Earth had, and one had said 3. So I mean, people get a lot of things wrong besides the separation of church and state. Things that you only have to look up in the sky to figure out. Yeah, I mean, you know, how do you solve a problem like misinformation? You know, I don't know. I mean, I think, you know, religious institutions have to do their job by educating their own people. I also think we need to have people who are making the case, not only in venues like this, but also in the national media, who are able to make the arguments. And the other thing we need, too, is we have to do so in a way that's not abrasive. And what I mean by that is that, you know, whether we like it or not, you know, especially traditional religious citizens and Christians in particular, have a kind of image problem. And I think some of it's not earned and some of it is. You know, some of it's kind of stereotypical, some of it's, you know, the result of people's experience. And I think we have to present ourselves and our positions in ways that are attractive and intelligent and winsome. And even sometimes we have to bite our tongue on occasion just to be able to get our point across. But I do think we have to begin with our own institutions, you know, our own schools and our own churches. And it's not such a bad thing for once in a while for a pastor from the pulpit to address some of these questions.
Can you speak to the fear of pastors to address political issues from the pulpit?
Yeah. Legally, pastors cannot be partisan from the pulpit. That is, they cannot use their pulpit to support a candidate. That's what partisanship means. It's actually a IRS regulation that was passed by Congress, and the chief sponsor of it was a senator from Texas named Lyndon Baines Johnson. He had a Thomas Jefferson problem. There were a lot of churches in Texas that didn't like Senator Johnson, who eventually became president of the United States. And so the IRS has this regulation that forbids partisan. In fact, there's actually some arguments that this is actually unconstitutional. Some scholars have made, Stephen Carter in particular at the Yale Law School has actually made this argument. He thinks that it could be challenged, but no one really has challenged it. So it's not actually part of the separation of church and state. It's actually a statute passed by Congress. So right now, pastors cannot be partisan, but that doesn't mean they can't address moral or social issues or even talk about legal questions as long as they don't support candidates. That's perfectly appropriate. Now, I tend to think that there's, even if there wasn't a law, I'm not sure pastors should support candidates as a matter of prudential judgment. But it depends on the election, right? I mean, if it's a, you know, there could be cases where, you know, extreme cases, but I think generally it may not be a good idea. But that's not, but I don't think the law should say so. It should be a kind of internal matter of the churches to make that judgment for themselves. But the law as it currently stands doesn't allow partisan politics.
This actually ties in with Dr. Arbor's question. How can secular humanism be accepted in public schools when it was defined as a religion per a federal judge in October 2014?
Yeah. Secular humanism is a term of art referring to a worldview or a point of view that is atheistic generally. In fact, one of the most important documents that's come out of the 20th century, actually I think there's 2 humanist, maybe 3 humanist manifestos, collection of major secular intellectuals, artists, and others, professors, declaring what they believe, and it's a form of atheism. I know of several federal court cases, but in the 70s and 80s that declared secular humanism a religion. But in those cases, it was declared a religion for free exercise purposes. That is, a citizen was denied certain rights because they were secular humanists. I think the question that the questioner is raising has to do with Establishment Clause. Why doesn't the government treat, or why don't the courts treat secular humanism as a religion for establishment purposes? And I can't really answer that question. The courts have decided not to. And so you think it would be kind of unfair, right? I mean, if they get free exercise rights, why can't their view also count as establishment? The courts have not gone in that direction. I think the cases that in which that argument has been made have been largely cases involving creation evolution cases. And my own view is that those were probably not the best cases. I think a better case in which this argument can be made are cases involving moral questions. Because there you don't get into the weeds of sort of the science theology issues. Not that those aren't good issues to discuss, they are. But I do think that in that question, I think people are less likely to see the deeper differences than they are in, let's say, the moral questions. So in the 1987 case, Editors of Aguilar, that was actually one of the arguments made by the defendants, that is the Louisiana attorneys that were defending the statute, the equal balance, or I think it was called equal balance, I think I got it exactly right, statute that required the teaching of creationism and evolution as taught. But the argument didn't fly because the court saw it as a science versus religion question. And so that's why, I mean, to answer the question, I think that there is some merit to making that distinction, but I do think that in terms of winning in courts, I think it's much, I think it would be, I think, a stronger case to kind of do what I suggested earlier on some of the moral questions.
Last question.
Okay?
How can we pray for you, your family, and your teaching at Baylor?
Oh, how can you pray for, did you guys hear that? How can we pray for you, your family, and teaching at Baylor? Well, that's very kind. Well, you can pray that the Lord not only strengthen me and my family, but and my wife, including my wife, but also Baylor University. Baylor is a wonderful place. It's an academic institution that is distinctly Christian, and it's one that has aspirations to be one of America's foremost research universities, while at the same time retaining its Christian heritage in its research and its teaching. And you know, because of the nature of the culture that we're in, there are going to be challenges to Baylor University over the next 5 to 10 years, and to pray that the leadership be courageous and that they would be willing to stand up for the gospel, even against pressures that right now may seem unimaginable.
Thank you.
Thank you very much.
Dr. Francis Beckwith.
Thank you.